I'm Katina Strauch's husband, and I've been married at this conference for 30-some years. It's become like I feel like a football season or something. It just comes around every year, and it's just part of our rhythm. And many years ago, she discovered this incredible guy, Bill Hannay, who's a very big deal lawyer, antitrust lawyer in Chicago. And the guy is so multi-talented. He's a Yalie, and he was a Supreme Court clerk, and he was a spizwink at Yale. He thinks nothing about standing up for an audience and singing, and he's become this, if you're new to the conference, every year he does something so extraordinary, and he just brings down the house, particularly on Friday. I'm going to have to read from there, which just fills me with dread. But he's having quadruple bypass surgery, and he's just good-humored up. You know, we were talking to him over the phone. He's a super guy, and now I'm stuck with reading this. Now, I stand on my feet and yak for a living. I really have no problem with it, and Katina's sort of amazed, and she doesn't like public speaking. I mean, you just do it, and your job's over with in an hour, which is great. But to read something, I mean, God, I'd have trouble reading through The Cat in the Hat, you know. And I remember my senior year in college thinking, I'm not educated. I have to go around and do important things to be an intellectual. And I went and listened to professors read papers, and it was so ghastly. They would read this god-awful thing, these convoluted sentences, and then they would look up or look through half glasses to let you know they'd said something profound, you know, and it was just violent. Now, what I'm going to read, the first half was totally understandable. Was the second half when he gets into the law that just, oh golly, it's very dense and all kinds of references to legal doctrines that are over my head. I'm a tort lawyer, and that's the ambulance chasing the profession is not. This Bill's intellectual property and stuff is just kind of amazing. But I'm going to take a shot at this, and everybody, I'm going to stand up at least, which is what I did. All right. Of minefields and minefields, legal issues in text and data mining. I've been asked to address the topic of opportunities and challenges for text and data mining in academia with a special emphasis on the legal issues involving these research techniques. To do so, I'll begin by taking you on a sightseeing trip through some mining regions outside the ivory-covered walls. Only by seeing the broader context in which text and data mining is used can one appreciate the legal issues in which academics must operate. Background: what has come to be called data mining is the process of extracting hidden knowledge from large amounts of raw data. Data mining goes beyond traditional searches of databases. In traditional database searches, information is returned in response to a direct query. Think historically of searching through a card catalog based on the Dewey Decimal System, or much more recently doing an internet search for books written by the eminent legal scholar Bill Hannay. Bill has written books on offshore tax shelters and just unbelievable things, and he ran the international section of the American Bar Association. He is a big deal guy. For the purpose of this speech, for example, I did a traditional search. I'm going to put the pages down so you see we're making progress. There's one down. Nexus Legal Database for court cases in the United States mentioning text mining or data mining. The answer was 116 cases, but a number were false hits. By contrast, in real data mining, what is retrieved is not explicitly in the database. Rather, the desired information implicitly emerges from patterns and relationships. The process of discovering and then analyzing such patterns and relationships has come to be termed data mining. The term became popularized in the early 1990s coextensively with the growth of what has come to be known as big data, meaning the proliferation of massive collections of data about individuals and about commercial transactions. Credit card companies, for example, have databases containing information of millions of credit card holders and billions of transactions. So does every grocery store, department store, and drugstore. Every time you buy something, your transaction is electronically recorded by the store clerk who clicks on the barcode of the product and then scans your credit card. That information is aggregated in massive databases and sold to marketing companies and manufacturers who can mine that data to learn potentially important information about the purchasing habits of buyers. For example, Reckitt Benckiser Group, a maker of consumer cleaning products, may find it commercially valuable to know that 7 times out of 10 a purchaser of paper towels also buys their Lysol brand spray disinfectant. Data mining finds these sorts of patterns and relationships using data analysis tools and techniques to build models. It combines tools from the disciplines of statistics in the field of artificial intelligence with database management techniques. Stu is down. This is called crossing the room, actually. It's a lawyer technique. You get way over here, and then you have to walk all the way across. And the audience pauses thinking, hey, he's about to do something important. In fact, I'm just turning the page. A data mining project can look either for trends or for anomalies. In the latter regard, one of the earliest commercial successes was in credit card fraud detection. Similar uses of data mining have been employed in law enforcement and national security. For example, the insurance industry compiles hundreds of thousands of claims reports from different insurance carriers into a common database and uses data mining techniques to identify potential claim fraud schemes. Where individuals have unusually frequent accidents in the sorry, I'm an ambulance chaser. And we had a bunch of workmen who were sitting on both sides of a truck, and it hit a bump, and they all fell off. I swear it was a genuine claim. It was not rigged. And of course, data mining, they just spotted insurance fraud, and they were all over that, just fought us like mad dogs. Okay. Some of the uses of data mining have been employed in law enforcement and national security. We know about NSA and their little stunts. For example, the insurance industry, okay, we got the insurance. Frequent accidents, same group of doctors, lawyers, and chiropractors repeatedly show up in connection with rear-ender collisions or slips and falls. It may indicate patterns which deserve further investigation. In the wake of 9/11, for example, a data mining company presented the Department of Defense with a data pattern analysis proposal geared towards improving the security of military installations in the United States and possibly abroad. It suggests that a rigorous analysis of personal characteristics of persons who sought access to military installations might be used to predict which individuals pose a security risk of those installations. At the same time, the pervasiveness of massive databases, especially ones containing personally identifiable information on matters of personal sensitivity, has led to increased concern about the government or private industry making dangerous intrusions into the private lives of millions of Americans, which they do. In June 2013, U.S. and U.K. newspapers reported the FBI and the National Security Agency had for a number of years been obtaining access to vast amounts of telephone and internet data on millions of American citizens, including those who only make calls to other U.S. numbers for data mining purposes unrelated to any specific target or investigation. The news stories resulted from the leak of classified and unclassified documents to the Guardian newspaper by former NSA consultant Edgar Snowden. The furor of the NSA data mining has intensified in the past few months and led to both lawsuits and proposed legislation. The pharmaceutical industry has also been making substantial use of data mining, particularly in connection with marketing to the doctors that prescribe medications. Drugstores and pharmacies, as a matter of business routine and federal law, receive prescriber identifying information when processing prescriptions. Many pharmacies sell this information to IMS America and other data collecting firms that analyze prescriber identifying information and produce reports on prescriber behavior. Data miners lease these reports to pharmaceutical manufacturers subject to non-disclosure agreements. In turn, detailers, salesmen who represent the drug manufacturers then use these reports to refine their marketing tactics aimed at doctors in order to increase sales. I actually could have presented this part. I think I've read it 3 times. Those practices took a dark turn when drug manufacturers began using the MON data to encourage physicians to prescribe drugs for off-label uses. Off-label use is the use of pharmaceutical drugs for an unapproved indication, or in an unapproved age group, unapproved dosage, or unapproved form of administration. While it's legal for a physician to independently decide to prescribe a drug off-label, it is illegal for the drug company to promote off-label uses to prescribers. Under the Food, Drug, and Cosmetics Act, manufacturers are prohibited from directly marketing a drug for a use other than the FDA-approved indication. The stakes for drug makers can be high. In 2009, Pfizer agreed to pay $2.3 billion in fines and penalties to resolve charges brought by the U.S. Department of Justice arising from the illegal off-label marketing of prescription drugs by the company. Using sophisticated prescription data mining and influence mapping analyses, Pfizer had targeted specific physicians who were visited by Pfizer's sales reps to promote off-label uses of Pfizer drugs. Litigation has been brought based on the sale of pharmacy customer prescription information to data mining companies who sell that information to drug manufacturers for marketing purposes. In an effort to ban this sort of data mining, various state legislatures enacted laws prohibiting the use of prescription information for marketing purposes. Blah, blah, blah. All right. Manufacturers fought back, brought litigation to federal court. Writing of the Supreme Court majority, Justice Kennedy held in Sorrell against IMS Health that the manufacturer's First Amendment rights have been violated. Sorrell struck down the section of the Vermont law forbidding the sale of prescriber-specific information by pharmacies to pharmaceutical manufacturers and pharmaceutical marketers. The Supreme Court rejected Vermont's explanation that the law was intended to protect public health and keep health care costs in check, saying the law could not withstand heightened scrutiny. Supreme Court found that heightened scrutiny was the appropriate standard guide to solve. In addition, these large-scale commercial mining. All right, let's go to academia here. Now, this is where it gets really dense. So now at last, we come to the subject of data mining in academia. We have come the long way around in order to illustrate the legal issues affecting the topic for today are derivative of and dwarfed by the far, far larger context of the use of data mining in law enforcement, national security, and commercial mining operations. Rules developed by courts or legislatures to deal with fraud, terrorism, and the invasion of privacy may be ill-fitting shoes when applied to the efforts of liberal arts or scientific scholars to find some new angle or insight into their discipline. And that's actually a good point. I'm looking over my glasses now. But what you all are doing is really small potatoes next to the NSA, for God's sake. You know? Listening to everything you do. What is an example of academic data mining? 2 years ago, Folger's Shakespeare Library director, Michael Whitmore, gave a speech describing his use of data mining methods to analyze Shakespeare's first folio. Whitmore processed 767 different 1,000-word excerpts of plays from the first folio to a piece of software called DocuScope. The software is based on a database of 40 million English linguistic patterns sorted into more than 100 categories. Filtering Shakespeare's classics through DocuScope uncovered patterns in Shakespeare's work that a human scholar trained in traditional academic reading methods would never see, such as in fact, in purely linguistic terms, Shakespeare's Othello is a comedy. He doesn't explain that. Well, I'll say no more on the merits of this piece of research at this point. I cite it merely as an example of how data mining might be used in the liberal arts. More to the point is to ask whether this research would have encountered any legal issues that need to be resolved. And I think we're getting to the meat of the thing, right? The first issue that might arise in text mining is whether there's any copyright problem in obtaining and searching the database. Here's the first folio. Maybe or maybe not. Master Will is, of course, long dead, and his works have been in the public domain for nearly 400 years. Yet there might be a question about copyright. Why? The answer lies in a particular version of the first folio that the researcher wishes to use. All the numerous printed editions of Shakespeare's works of the 19th century are out of copyright. It would likely be true that any modern electronic word searchable edition is in copyright. Shakespeare's words are not copyrighted, but the electronic version of them might be. If you go to the trouble of converting an old out-of-copyright print edition of Shakespeare into a Microsoft Word document or some other e-text, your e-text of it may well be copyrightable. Thus, while there are several websites that offer a free electronic edition of Shakespeare, you should check to make sure that the version you plan to search is not somehow protected. We'll need to revisit the copyright question later, but let's go on with our discussion of the Shakespeare data mining project. So there would seem to be no copyright issue as such. Presumably there is no problem in accessing the non-copyrighted edition of the first folio. By that I mean that the version you are working with has no electronic lock on it that you would have to unlock or possibly circumvent. So is there anything else to worry about? Yes. We need to know what search engine or data mining software you're planning to use. Possibly the software is proprietary. You may need permission to use it. DocuScope, for example, is owned by Carnegie Mellon University, from whom you must obtain permission to access and use the software. I have not seen their form of license agreement, but it may include some requirements relating to publication and research using DocuScope. Well, that's a pretty easy set of steps to go through in order to data mine the first folio, easy compared to other situations. The difficulty factor would increase if the contents of the database you want to search is copyrighted. Let's say you want to apply DocuScope to the collected works of William Faulkner and Ernest Hemingway, both of whose works are still under copyright. First, you would have to find an electronic database containing their novels and short stories. Let's assume that you can find all of them in the Google Books Project or HathiTrust Digital Library. The issue of whether Google had a right to scan all the books in the world is still an open question before Judge Chin. But the district court decision in the HathiTrust case, issued by Judge Bayer, recognizes that such copying constitutes fair use of the works. Because the use for scholarship and research was transformative by providing superior search capabilities rather than actual access to the copyrighted works and facilitating access for print-disabled persons. Now, his citation here is very interesting about transformative, something I actually know about. Is the case of the Bill Graham Archives against Dorling Kindersley. Bill Graham, for you baby boomers out there, owned the Fillmore Ballroom. Does that ring any bells? It was in San Francisco, and the great bands played there. Country Joe and the Fish, Big Brother and the Holding Company, Jefferson Starship, and wow, you know. And they had these posters that just sort of swept the nation visually, what we call a meme today, I guess. They're all completely cribbed from the 19th century. There's not an original thing about them. But the baby boomers are so self-obsessed, you know, like, wow, these are our posters, and isn't this cool? And, you know, Bill Graham owned these things. And somebody put together a book, a history of the Fillmore, and they reproduced these posters, and that was the issue. Well, the thing squeaked through as transformative because they were quite small the way they reproduced them, and he had put them on a page. There were so many of them. He had put them on pages in strange patterns, sort of like fallen autumn leaves or something. The court said, well, you know, it's kind of different what they're doing, and it's not being used to advertise an event or something, so it's transformative. So that's okay. All right. Logically, a researcher only needs or would want to engage in text or data mining if, first, there is a large enough collection of books or articles to make the effort meaningful, and second, the collection of works is machine readable. Thus, a biochemical researcher might be interested in data mining for the past 50 years' worth of scientific journals, but only if they are electronically searchable in the right kind of way. But access is no easy matter. There's the rub. To obtain access to all of Elsevier's past and current journals, for example, may require special permission and payment of fees that are not inherent in the university's current subscriptions. Elsevier's current policy on data mining includes the following. We wish to understand our customers' text mining requirements, and as practically every content mining request has a different goal, and there is not a common solution to provide this. Consequently, we request the customers looking to mine our content should speak to their Elsevier account manager or should contact us directly. We will then discuss the mining request. Mining requests are often content specific. Customers can choose to mine our full text content, abstracts, data, and other materials. A charge may be applicable depending on the request. Okay, if you already have access to the copyrighted work via Google Books or Hannay Trust, you may choose to skip seeking permission to data mine. Of course, you better check with the university's lawyers first, who won't answer you, but conceptually you might be able to run the search. But if there are access, no, he didn't write that, I did. That's my footnote. Bill didn't say that. But if there are access problems because, for example, technological protection measures, TPMs, have been installed in the database to control or limit access, there's more of an issue. Assuming you had access to some sort of device or software that could cancel or circumvent the TPM, can you legally use it to do so? And the answer is on the outer edge of legal certainty, and this is where it really gets tough. Maybe you're all more familiar with this than I am. Digital Millennium Copyright Act, God bless us, includes TPM provisions that ban both sets of circumventing TPMs used by copyright owners to control access to their works, as well as any device, service, or technology that is primarily designed or useful for circumvention. However, it does include 7 limited, and it says, and generally inadequate exceptions, but one of them is law enforcement, which is just totally blown through the whole thing. It says, we can look at anything, you know, so that's a pretty big exception. But anyhow, it does mention, you know, fair use and stuff is in there. DMCA bans consumers from circumventing TPMs to make fair use of projected digital work, such as making a backup copy of a copy-protected CD that they have purchased. A possible crack in this wall has opened in the last few years as a result of 2 decisions by the U.S. Court of Appeals for the Federal Circuit. That's the one that's heard out of D.C. U.S. Code prohibits any person from circumventing a technological measure that effectively controls access to a work protected under this title. Federal Circuit confronted this issue in Chamberlain Group versus Skylink. The court noted that the Congress enacted the DMCA. It chose to create new causes of action for circumvention and for trafficking in circumvention devices. So the act says this is a new cause of action you never had before. You can be sued for it. Congress did not choose to create new property rights. Now that has to be seriously thought about, property. You know, the cause of action, but no property right. Accordingly, the court held this section prohibits only forms of access that bear a reasonable relationship to the protections that the Copyright Act otherwise affords. Does anyone understand that? No. You have a cause of action, but no copyright, no new property right, which is copyright. I have a right in this property, right? But you must, a copyright owner suing must prove that the circumvention infringes or facilitates infringing a right protected under the Copyright Act. Has anything changed? Seems to me it's the same thing, isn't it? I've got a copyright and you've gotten around it through this device, and so I'm suing under copyright. All right. Bill can make it all, so it seems so logical. The following year, the Federal Circuit again dealt with a claim of circumvention under the DMCA and reaffirmed its ruling in Chamberlain. Storage technology versus custom hardware. Devices to circumvent a data locking protocol constitute a violation of DMCA. CHE, this is the Chamberlain, CHE is custom hardware engineering, repairs STK libraries or silos that are connected to library control units. Is that familiar to y'all? I've never heard of it. The Court of Appeals concluded it was unlikely that Storage Tech could succeed on the merits of its copyright claim, and therefore, to the extent that CHE's activities do not constitute copyright infringement, Storage Tech is foreclosed from maintaining an action. I'd like 3 paragraphs instead of 1 because I don't get it, okay? There was a lawsuit against Storage Tech which uses devices to get around data locking.
I think I can explain it.
All right, good, go.
In relationship to the
Go.
Skylink case.
Go.
And that is that they circumvented some digital locks, but what they wanted to do was not a violation of copyright.
Because they were repairing.
What they were trying to do was create garage door openers that would work with different brands of garage, generic garage door replacement openers. And so they needed some coding from the original devices. They broke into these digital locks in order to make the coding work, but that doesn't implicate any of the 5 rights protected under copyright. And for that reason, the court said that there was no separate cause of action just for circumventing the digital lock. You had to circumvent the digital lock to do something that implicates one of the copyrights.
Do you understand now? Okay. See, I told him to read the thing. The court held, to the extent Storage Tech's rights under copyright are not at risk, the DMCA does not create a new source of liability. The Federal Circuit reasoned that because the DMCA must be read in the context of the Copyright Act, which balances the right of the copyright owner against the public interest in having appropriate access to the work, we've not found a violation of DMCA. There's only a violation was intertwined with a right protected by copyright. 5 years later, the Court of Appeals, well, let me get back to you. He says CHE repairs STK libraries or silos that are connected to library control units. What does that got to do with the garage door?
That's a different case, and I'm afraid I'm not familiar.
Okay.
Sorry.
Garage doors, I can sort of dismiss.
Garage doors was the Skylink.
When you start hearing about libraries, you go, "Oh, well, that's what we're here for." Anyhow. All right, the Court of Appeals considered a circumvention claim and declined to follow the previous stuff, i.e. it's got to be linked to violation of copyright. This is the Ninth Circuit. Now, the Ninth Circuit is California. Of course, they're the famous wackos of the nation. But when it comes to copyright, they normally are spot on. New York, California, they know what they're talking about. But they're saying that we can take it aside, away from copyright. One might have concluded the circumvention to engage in fair use would not be actionable. However, in light of the Ninth Circuit's contrary decision, such a conclusion would entail a certain amount of risk. According to the conservative approach, for the moment at least, would be to avoid circumventing technological protection measures and to opt to seek permission from the owner of the protected works. Okay, that's pretty okay, right? Ask permission rather than forgiveness. Finally, even without the existence of TPMs barring access to a protected work, there may be a contractual licensing constraint on the abilities of an academic researcher to freely mine the works otherwise available. Contractual provisions may say you can't do it. And these override copyright because you've agreed, I won't do it. You know, and that's that thing that you agree and you haven't read it, you just punch it, right? Everyone does that. You don't read your life insurance policy. Copyright law has not been interpreted to preempt or override contractual restrictions. The university or library holding the license may be deemed to be in breach of a license agreement if it permits data mining that is prohibited by the agreement. Even open access journals may present a problem if the license is a restricted one. With license agreements is with the other aspects of the data mining project, such as copyrightable and TPMs, it's important for the researcher to consult closely with the library staff, blah, blah, blah. Okay. Thank you, Bill.
So, Bill actually sent me this paper the middle of last week. And I quickly looked at it and I wrote back to him, not realizing that he was about to go under the knife. He didn't know it either. I said to him, this is very interesting, all these legal cases and precedents which basically tell us that the right to read is not the right to mine. And that there are huge numbers of complexities here. But the people in this audience will be very interested in a kind of pragmatic way. What is it that I'm supposed to be doing and how should I be thinking and what's really going on in my academic environment today vis-a-vis text and data mining. In your handout, you'll see that, when you click on the Teresa Lee Charleston presentation, you'll see that a lot of organizations have come up with licensing language for text and data mining that they have put into their contracts. My understanding of these is, I should say, have attempted to put in their contracts. Because a lot of these are model licenses, and when push comes to shove, the publishers don't necessarily accept the language in your model license. So my understanding from the folks who've actually tried to do this is that sometimes it works and sometimes, or more often than not, it doesn't. The publishers that I've spoken with say, well, this is early days. We really need to understand what mining means, how scholars will be using it. We don't understand this very well, and therefore, at this time, we want all these requests to come through us, and we want to be able to say yes or no. They also often need support. There's no library that can probably easily download or does download the entire Elsevier content. Elsevier probably needs to help a researcher in this regard. Ditto for a lot of other publishers. So I've encountered a lot of publishers who are very willing to work on a one-on-one case with individual scholars. ProQuest, Gale, Elsevier, lots and lots of them. And I think what librarians are trying to do is to get beyond that and say, this is something that is permissible. So I think it's not that the publishers are unwilling right now, but they feel that they don't clearly understand how much work will be involved in supporting researchers. They don't understand what researchers will do with this. They don't understand if the uses will truly be transformative. They often want various credits and things like that, it makes everything into a case-by-case situation. And what we're trying to get past that, we're trying to get past that in our licenses and generalize. Now, I know I'll be interested to hear what you folks have to say. I know of a couple of exceptions. I heard a JSTOR presentation a couple of weeks ago. They have been supporting text and data mining in a fairly automated way since 2008 or 9. And apparently you can, and I haven't tried this, apparently you can go to the JSTOR site as a scholar or librarian or whoever you are and actually work through a number of their texts without getting any special permissions. The stuff is available to you unless you go to a very particular kind of application where you need detailed support. And JSTOR is working on making this more and more comprehensive and transparent. And I was pretty impressed with what I saw in that presentation. We also talked a week or so ago with the New York Times about a site license process with CRL, and they have told us that large chunks of the New York Times are in fact available for not-for-profit, transformative, academic use without any special hoops to jump through or permissions. However, if you are in the commercial sector, you can't do that. You have to contact them. You have to pay money, and other kinds of things happen. So those are two providers I know that apparently try to facilitate text and data mining for the end user without intervention. Now, I don't know if you found any others who do that, who are helpful in that regard. Yeah.
Sure. I'm Dylan Moulton. I was with Springer, so I can't speak for Springer right now, but this is the type of conversation that we were a part of and is actively going on right now. So I'm not speaking for them, but I'm speaking from experience with. It's really a three-part conversation that we're having right now. It's one, will we do it? And everything that, when it was a we, it seemed it was an inevitability. The second one, and this is where the step really is how do you do it? Which is, do you have a gateway? Do we do an API? Everything, when you're the size of a company like Springer, needs to be scalable, right? So do you build a gateway where it only authenticates so that you only have what you can only dig and mine through what you have access to, rightfully what you paid for, and then the costs associated and how do you technically do that? And then there's a third part, which is contract and pricing, and if you price it, which is, okay, great, the answer hypothetically is yes. The answer then hypothetically is, great, we can do it with an API, and we know how to do it and authenticate it. And then there's that third part of, well, how much did it cost to build that gateway? How do you recoup that? Do you charge it? Is it just another way? And the conversations that we're having, and I'll zoom out of Springer and just say in publishing when I speak with my colleagues, is this just another way of accessing what you've already bought? And this, or have access to rightfully one way or another. And that's the conversation where the camps start factioning off a little bit. And it's not that the conversations aren't happening. It's one of those where it's how do we technically deliver it, how do you build around it, and so on, and make it scalable. So it's an exciting conversation internally, and my experience outside and within Springer has been not that it's adversarial, it's more of how and on what timeline and what's the language look like.
Well, one of the speakers at Charleston last year was, I don't know if I can pronounce her name correctly, Heather Piawar, who was the researcher who made the news in the Chronicle of Higher Education and other places because she wanted to mine Elsevier data and went through a whole lot of hoops to do that. So she got wide coverage, and of course Katina, being Katina, invited her to come and talk about her experiences here. I mean, one of the things that comes as no surprise to anybody here, including you, is that librarians really don't want to pay a second time for the material that they've already licensed, a huge expense every year the first time. And I guess, while we understand that you may have to do some technical development or infrastructure or APIs or whatever to facilitate this, I guess we believe that that is part of the normal evolution of publishing and the publishing business, and that every time a wonderful enhancement is made, maybe the ability to read on a mobile device or some ADA thing or whatever, that doesn't mean that it should incur an additional charge.
No, and that's the conversation that's happening. It's one of those where, what is a PDF going to mean in 100 years? What is EPUB going to mean in 100 years? What is data mining going to mean in 10? These are the conversations that are having internally as well. And these are the ones where when you have conversations with your representatives, make it known. Because each publisher is at their own point of this conversation as it comes in. Being formerly from the STM side, it's a little bit farther ahead than some of the other publishers I've heard. And it's just larger, so more were coming to us at the time. Make it known. And it's one of those where it is formative time. I have heard internally multiple sides to the same argument.
Yeah, I mean, in a way, it's kind of like ADA. Everybody's talking about it, and everyone's intentions, I'm sure the publisher's intentions are quite good, but we have to find a way to actually realize what we're talking about, and that becomes harder. Kevin, you were...
I was just going to say that you were talking about, not wanting to pay twice, but sometimes cost is not the only obstacle. After Heather's presentation here, we had a researcher contact Elsevier and say, I'd like to do text mining, because Elsevier had said during that presentation or afterwards that they would make an API available with relatively simple licensing terms, sort of a click-through license. And it turned out, in fact, that the institution, our researcher, asked the question, but we were given a rather extensive license that we were asked to sign before our researcher could download the API. And one of the provisions of that was that he would have to explain in pretty great detail his research project and get permission. And you may know that that doesn't fly with researchers. It doesn't fly if the library asks him to do that, and it doesn't fly when the vendor does. So we ended up continuing to negotiate this license after our researcher had walked away and said, I'm not interested. And we finally decided it just wasn't worth it.
And it doesn't scale. You can't.
No, it really
That's
doesn't.
the issue.
You can't do more than 10 of that before you crumble under the weight of it. Yeah. Scott.
One of the issues seems to be that when you do data mining like that, you're essentially downloading either the entire corpus or you're creating a secondary copy of that, and then you get into the question of is that copy preserved somewhere? Do you have some sort of repository where you're keeping data locally? So would we keep, let's say Springer, your former, would we keep Springer's corpus locally? Do we share that or not? Because normally when we license, we're licensing access to something, but we're not reproducing the entire corpus of a publisher at any one time. We have bits and pieces of it downloaded, but to say take the entire thing, and what do you do with that? What do you do? Does that researcher then just hold on to it forever? Do they keep incrementing that data set as the publisher keeps publishing? I mean, it's a longitudinal data set. It's going to keep growing. So I think there's a host of questions that would apply to that data. It's not the same thing as just saying, well, I'm accessing and downloading articles here and there. You've got the entire thing at once, and how do you safeguard that? How do you store it, or do you store it?
And however unfond I am of the complicated, convoluted STM suggested language, I think it's worth a look because it actually underscores all of these issues that have been mentioned here. What happens if, and what do you do about a whole corpora of material, and how do you deal with this? And I think the STM materials actually outline from the publisher's point of view their set of concerns. I don't want to be shot dead here by my librarian colleagues, but I think this is something that, of course, practically speaking, is in evolution. I remember when we signed the first JSTOR license in the late 90s, the interlibrary loan provision was that we would first we would tell JSTOR every time we did an interlibrary loan request so that they could understand. They could understand what that meant and how it was being used and that it wasn't being abused and all those good things. And interlibrary loan is maybe a bit simpler than text and data mining, but it's pretty complicated stuff, and can certainly could impinge on revenue. And we don't do that anymore. And so there may well be things that we do now in 2013, 14 that we will, as we get to a greater comfort level, not need to worry about so much. you know, my view about publishers and text and data mining is that all the ones I've talked to have been perfectly willing to have a conversation and perfectly willing to understand and whatever. But as Kevin has said, this is just, you know, it's really nice and it's collegial and you have these great conversations, but you can't repeat this kind of thing. So we will have to evolve to a better place. And meanwhile, I think, you know, this is exactly like ADA. This is something that librarians need to be very much aware of. I mean, there's an emphasis now in not just colleges for students, but also even in the high school level, that students should do research. And what I hear from colleagues is that in more and more classes and with more and more professors and more students, there's a kind of interest in teaching students how to work with these data across publishers and learn something, you know, find something transformative or interesting or new or different. And so, you know, while the demands on us in our institutions right now may not be high and heavy in most places, I think this is just going to become a normal part of use of digital resources. So the question is, how do we get from here to there, I think.
I'm just wondering if you've heard about any initiatives across universities to create a sandbox to allow this kind of work to be done in an environment where the content is more reasonably protected. Because this notion of downloading the entire corpus is a huge part of the problem. You know, with storage technology, you can put a terabyte of content on an external hard drive the size of a clutch purse. And now it's my entire corpus is sitting on the back seat of some grad student's car. And the librarian didn't have anything to do with that. I mean, the librarian's not doing the research, but the librarian's the person who's coming to ask. And so if there were a safe place where a consortia was actually hosting this content and allowing people to come in and play, it would really change the conversation.
Does anybody know of cross-institutional sandboxes, let alone inside institutional sandboxes?
PubMed. PubMed is kind of a sandbox.
Pardon?
For the articles that it has collected.
I mean, there's no
Yeah.
text and data mining, but it's sandbox. Well,
Yeah, I don't know. Do you know how one would mine PubMed though?
Well, the way it's licensed, I think it would be impossible, just because the National Institutes of Health have basically said, we're not going to license this in a uniform way, we're going to make it the responsibility of each researcher. In most cases, publishers have arrived at their own agreements, and the permissions that are given to PubMed vary a good deal, but I think they would almost never include the ability to download the corpus or items in the corpus or data mining.
Yeah, and I think a really interesting thing here is that the publishers have shown a lot of many publishers have shown much goodwill in working with researchers in this area. But researchers often don't want to just look at Springer content. They want to look at, you know, some form of neuroscience research across a number of publishers. And that, I think, is where, I think that's much more important as a data mining activity and much, much more difficult right now. So you know, it's my understanding that the industry is actually talking about maybe how to interoperate some of these texts.
That's one of the interesting parts of the conversation is when you get inter-institutional or inter-publisher with that, because then you can get into comparisons of things that publishers really do protect more, comparisons of use in individual institutions' definitions of value and things like that, which is what a publisher, I would imagine, would be more concerned about from the conversations I've had than someone running off with, you know, a quarter of your collection or something like that, which is, you know, something that we've been used to or getting used to over the years, compared to Sage, TF, Springer, Wiley, Elsevier, so on down the list, and then all of this is in a sandbox, and someone can go in and click in and, hey, by the way, I'm going to cross-reference that to my licenses and what I've paid for it, and then that ends up out there. Now that's an interesting and a separate conversation. I want to open that one up there. But these are the types of things that we're looking at as well, which are, I would argue, more interesting is the wrong word, but more in-depth in this next step than initially for research to get it for legitimate research uses.
Were there any other comments? I think these are available online for your perusal, but last November, I think it was maybe the 13th, and this July, sometime in mid-July, the Center for Research Libraries held 2 widely attended webinars on text and data mining. The first one, last November, was a number of examples, sort of use cases coming to us from like Princeton, Yale, Elsevier, and so on. They were interesting. And then in June, we went, July of this year, sorry, the webinar was the publishing industry, a handful of people in the publishing industry telling us some of the initiatives that they're working on. We want to do another one at the beginning of 2014, which I think is overdue, and that is to feature libraries that are supporting text and data mining on their campuses and what it takes. How hard is it? How easy is it? What are the obstacles? How do you have to resource and staff up and so on? And I think, if any of you know or are part of institutions that are actually engaged in that kind of staff support, I'd like to hear from you so we can organize that. Duke may be one of those. I heard a wonderful presentation from Columbia who's actually got staff, professional data type staff assigned to this activity. So I think this is something that we're all looking at. It's really exciting. I think it will help develop new knowledge. We just have to be prepared to accept this additional new challenge of that technology brings to us. Let's take another 5-minute break, and then Kevin is going to come back and talk with us about MOOCs.